Good morning, students. Starting with this new chapter, which is Introduction to the Environment Protect Act 1986. Right. So basically, this act is an act to provide the protection and improvement of the environment for matters connected there with various decisions were taken at the United Nations Conference on the Human Environmental held at Stockholm in June 1972, in which India participated to take appropriate steps for the protection and the improvement of human environment. Right? And whereas it is considered necessary further to implement the decisions aforesaid in as far as they relate to the protection and the improvement of the environment and the prevention of hazards to human beings, other living creatures, plants, and the properties. So it was enacted by Parliament in the 37th year of the Republic of India under the Article 253 of the Constitution of the India. So it came to the force on 19th November 1986. So this act is an umbrella legislation designed to provide a framework for the central government coordination of the activities of various central and state authorities established under the previous laws such as the Water Act and the Air Act. Right? So what are the objective of this act? So first is to coordinate the activities of the various regulatory agencies already in existence. Second is creation of authority or authorities with adequate powers for the environmental protection. Third is the regulations of the discharge of environmental pollutants and handling of hazardous substances. And the last one is the speedy responses in the events of accidents threatening environment and the punishment to the those who endanger human environment, safety, and the health. So there are some definitions of terms under this act, which is first is environment. So it includes water, air, and land, and the interrelationship with exist among and between the water, air, and the land and human beings, other living creatures, plants, microorganisms, and the property. Second term is the environmental pollutant. So it means that any solids, liquids, or gaseous substance present in such concentrations as may be or tends to be injurious to the environment. Right. Third term is environmental pollution. So it means that the presence in the environment of any environmental pollutant. Fourth one is the handling. So handling in relation to any substance means the manufacturer, processing, treatment, package, storage, transportation, use, collection, destruction, conversion, offering for sale, transfer, or like of such substances. Right. Next is a hazardous substance, which means that any substance or preparations which by reasons of its chemical and the physico-chemical properties or handling is liable to cause harm to the human beings and other living creatures, plants, microorganisms, property, or the environment. The next definition is occupier in relation to any factory or premises means a person who has control over the affairs of the factory or the premises and includes in relation to any substance the person in possession of the substances. Right. Next is the prescribed means prescribed by rules made under this act. Next is power of central government to take measures to protect and improve the environment. So there are tips here, which is power to the central government also gives the idea of the function that the central government, especially the measures to be taken by the government. This point may be given in point number 2, right, which is mentioned below. So talking about the first point, which is subjected to provisional of this act, the central government shall have a power to take all such measures as it seems necessary or expedite for the purpose of protecting and improving quality of the environment and preventing, controlling, and abating environmental pollution. Right. Second point is in particular and without prejudice to generality of the provisions of subsection 1. Such measures may include measures with respect to all or any of the following matters, namely, first is coordination of action by the state government, officials, and the authorities. Second is planning and execution of a nationwide program for the prevention, control, and abatement of environmental pollution. Third is laying down standards for the equality of the environment in its various aspects. Right. Next is laying down standards for emission or discharge of environmental pollutants from various sources whatsoever, provided that different standards for emission or discharge may be laid down under this clause from different sources having regard to the quality or compositions of the emission or the discharge of the environmental pollutions from such sources. Restriction of the areas in which any industries operations or the processes or the class of industries operations or the processes shall not be carried out or shall be carried out subject to certain safeguards. Laying down procedures and safeguards for the prevention of accidents which may cause environmental pollution and the remedial measures for such accidents. Laying down procedures and safeguards for the handling of hazardous substances. Examination of such manufacturer process materials and substances are likely to cause environmental pollution. Carrying out and sponsoring investigations and research relating to the problems of environmental pollution. Inspection of any premises, plants, equipment, machinery, manufacturing or other processes, materials or substances, and giving by order or of such direction to such authorities, officials or persons at as it may consider necessary to take steps for prevention, control and abatement of environmental pollution, establishment or recognition of environmental laboratories and institutes to carry out the functions which is entrusted to such environmental laboratories and institutes under this act. Collection and dissemination of information in respect to the matters relating to the environmental pollution, preparing of manuals, codes or guides relating to the prevention, control and abatement of environmental pollution. So such other matters as the central government deems necessary or expanded for the purpose of securing the effective implementation for the provision of this act. So third point is the central government may it considers it necessary or expanded so to do for the purpose of this act by order published in the official gazettes constitute an authority or authorities by such names or names as may be specified in order for the purpose of exercising and performing such of the powers and functions, right. Including the this power to issue directions under the section 5 of the central government under this act and for taking measures with respect to such of the matters refer into some section 2 as may be mentioned in the order and subject to the supervisions and control of the central government and the provisions of such order, such authority or authorities may exercise and powers or perform these functions or take measures so the mention in the order such as if the such authorities or authorities has been empowered by this act to exercise those power or perform those functions or take such measures. Next is the appointment of officers and their powers and the function. So first is without prejudice to the provision of subsection 3 of section 3. So central government may appoint officers with such designation as it thinks fit for the purpose of this act and may entrust to them such of the powers and function under this act as it may deem fit. Second is officials appointed under subsection 1 shall be subject to general control, direction of the central government, or if so directed by the government, also of the authority or the authorities, if any constituted under subsection 3 of section 3, or any of the authority of the officer. Next is a power to give direction. So notwithstanding anything contained in any other law, but subject to the provision of this act, The central government may, in the exercise of its powers and performance of its functions under this Act, issue directions in writing to any person, officers, or any authorities, and such person, officer, or authority shall be bound to comply with such directions. So there is explanation for the avoidance of doubts. It is hereby declared that the power to issue this direction under this section includes the power to the direct the closures, prohibition, or regulations of any industry, operation, or process. B is a stoppage or regulation of supply of electricity or water or any other services. Now, powers of entry and inspection. So, first is subject to provisions of this section. Any person empowered by central government in this behalf shall have a right to enter at all reasonable times with such assistance as is he consider necessary. Any places, first is for the purpose of performing any of the function of the central government interested to him. Second is for purpose of determining whether and if so in what manners any such functions are to be performed, or whether any provisions of this act or the rules may thereunder notice, order, directions, or authorizations served, made, given, or granted under this act is being or has been complied with. Now, third is for the purpose of examining and testing any equipment, industrial plant, record, register, document, or any other materials object, or for conducting a search of any building in which he has a reason to believe that the offense of under the this act or the rules made there under has been or is being it is about to committed, and for seizing any such equipments, industrial plant, record, registers, document, and other materials object, if he has a reason to believe that it may furnish evidence of the commission of an offense punishable under this act of the rules made thereunder, or that such seizures is necessary to prevent or mitigate the environmental pollution. Second is every person carrying on any industry operation or the process of handling any hazardous substance shall be bound to render all the assistance to the person empowered by the central government under the subsection 1 for carrying out the functions under that subsection. And if he fails to do so without any reasonable cause or excuse, he shall be guilty of an offense under this act. Third is if any person willfully delay or obstruct any persons empowered by a central government under the subsection 1 in the performance of his function, he shall be guilty on offense under this act. Fourth is the provision for the Code of Criminal Procedure 1973 or in relation to the state of Jammu and Kashmir or an area which that code is not in force, the provisions of any corresponding law in force that state of the area shall, so far as may be, apply to any search or seizures under this section as they apply to any search or seizure made under the authority of a warrant issued under section 94 of said code, or as the case may be under the corresponding provisions of the said law. Next topic is a power to take samples and procedures to be followed in connection therewith. So first is the central government or any officer empowered by it in this behalf. So shall have this power to take for the purpose of analysis samples of air, water, soil, and other substances from any factory, premises, or other places in such manner as may be prescribed. So the result of any analysis of the sample taken under subsection 1 shall not be admissible in evidence in any legal proceeding unless the provisions of subsection 3 and 4 complied with. So subject to the provision of the subsection 4, the person taking the sample under the subsection 1 shall serve an occupier on his agent or person in charge of the place notice, and then there in such form as may be prescribed of his intention to have it so analyzed. So in the presence of the occupier of his agent or person, collect the sample for the analysis, cause the sample to be placed in a container or containers which shall be marked and sealed, and shall also be signed both by the person taking the sample and the occupier or his agent or the person. Send without the delay containers or the container or the containers to the laboratory established or recognized by the central government under the section 12. So when the sample is taken for analysis under the subsection 1 and the person taking the sample serve on the occupier or his agent or person a notice under clause A of subsection 3, then in case where the occupier, his agent or person willfully absents himself, the person taking the sample shall collect the sample for analysis to be placed in a container or containers which shall be marked and sealed and shall also be signed by the person taking the sample. So in case where the occupier or his agent or person present at the time of taking the sample refuses to sign the marked and sealed container or containers of the samples as required under clause C and subsection 3, the mark and seal the mark and seal container or the container shall be signed by the person taking the samples, and the containers or the containers shall be sent without delay by the person taking the sample for the analysis to the laboratory established or recognized under the section 12, and such person shall inform the government analyst appointed or recognized under section 12 in writing about the willful absence of the occupier or his agent or a person, or as the case may be his refusal to sign the container or the containers. So there are some rules to regulate environmental pollution, which is the central government may by the notification in the official gazette makes rules in respect of all or any of the matters referred in the section A. So in particular and without prejudice the generality of the foregoing power, such rules may be provided for all or any of the following matters, namely the standards of quality of air, water or soil for various areas and purposes, the maximum allowable limit of concentration of various environmental pollutants including noise for different areas, the procedures and safeguards for the handling of hazardous substances, the prohibition and the restriction on the handling of hazardous substances in the different areas, the prohibition and restriction on the location of industries and carrying on process and operations in the different areas, the procedures and safeguards for the prevention of accidents which may cause environmental pollution and for providing for remedial measures for such accidents. There are some environmental laboratories. First is central government may, by notification in official gazette, establish one or more environmental laboratories, recognize one or more laboratories or institutes as environmental laboratories to carry out the functions entrusted to an environmental laboratory under this act. Second is this the central environment the central government may, by notification in official gazette, make rules specifying the functions of the environmental laboratory, the procedures for the submission to the state laboratory of the samples of air, water, soil, and other substances for analysis or test, the form of laboratory reports thereon, and fees payable for such report, such other matters as may be necessary or expended to enable that laboratory to carry out its function. So penalties for the contravention of the provisions of the act and the rules, orders, and the direction. So whoever fails to comply with or contravenes any of the provisions of this act or rules made or orders or direction issues thereunder shall in respect of each such failure or contravention be punishable with imprisonment for a term which may extend to 5 years with a fine which may extend to 1 lakh rupees or with both in case the failure or contravention continues with additional fine which may extend to 5,000 rupees for every day during which such failure or contravention continues after the conviction for the first such failures. So if the failures referred to in a subsection 1 continues beyond a period of 1 year after the date of conviction, the offender shall punishable with imprisonment for a term which may extend to the 7 years. So offenses by the company. So where an offense under this act has been committed by a company, every person who at the time offense was committed was directly in charge and was responsible to the company for the conduct of this business of the company, as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punishable accordingly. So provided that nothing contains in this subsection shall render any such person liable to any punishment provided in this act, if he proves that the offence was committed without his knowledge or that he exercised all due this prevent the commission of such offence. So notwithstanding anything contained in subsection 1 where an offence under this act as committed by a company and it is proved that the offense has been committed with the consent or convenience or attributes to any neglect on the part of any director, manager, secretary, or other officers to the company. Such director, manager, secretary, or other officer shall be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. So explanation for the purpose of this section, company means any body, corporate and includes a firm or other associations of individuals. Director in relation to the firm means partner in the firm. And last topic is offense by government department. So where an offense under this act has been committed by any department of government, the head of department shall be deemed to be guilty to the offense and shall be liable to the proceeded against and punished according. So provided that nothing contained in this section shall render such a head of department liable to any punishment if he proves that the offense was committed without his knowledge or that can be exercised all the diligence to prevent the commission of such offense. So, notwithstanding anything contained in subsection 1, where an offense under this act has been committed by a department of government, and it is proved that the offense has been committed with the consent and connivance of or is attributable to any neglect on the part of any officers and other than the head of department, such offers shall also be deemed to be guilty of that offense and shall be liable to the proceeded against and punished accordingly.